An offer is a statement by one party of a willingness to enter into a contract on stated terms, provided that these terms are accepted by the party or parties to whom the offer is addressed. The offer may be made orally, be written, or implied by conduct. The first requirement for a binding contract is that an offer must have been made. An offer is defined as an expression of willingness to contract on certain terms, made with the intention that it shall become binding as soon as it is accepted by the person to whom it is being addressed. The offer may be communicated in writing, orally, or by conduct. Until the offeree knows about it, he can take no actions in reliance on it. An offer cannot be accepted if it reaches the offeree only after the date expressly specified in it as the last date for acceptance. An offer cannot take effect until it is received. Unilateral offer occurs when one party promises to pay to another party a quantity of money or do some act if the other party does or refrains from doing something. Reward cases generally fall into this category. In the case of Carlill and Carbolic Smokeball Company, an advertisement promised that the company would pay £100 to any user of a Carbolic smokeball who caught influenza. The advertisement stated that the company had deposited £1,000 into their bank to show sincerity. The defendant argued that the plaintiff should have notified the defendants of her acceptance of the offer. In this case, it was held that the advertisement was an offer to the whole world, and when offer is made to the whole world, for example, a reward for return of lost property, the finder need not notify the owner in advance of his acceptance. He can accept by finding and returning the thing, and the same principle was applied in this case. This was a unilateral offer. Termination of an offer. An offer may be terminated in a number of different ways before it is accepted. It may be terminated by withdrawal, rejection, lapse of time, by the occurrence of a condition, by the death of a party, or by supervening incapacity. Withdrawal. As a general rule, an offer can be withdrawn at any time before it is accepted. Notice of the withdrawal must be given and must actually reach the offeree. It is not withdrawn merely by acting inconsistently with it. For example, disposing of the subject matter. The general rule that the withdrawal of the offer must be brought to the mind of the offeree, subject, however, to a number of exceptions. Rejection. An offer is terminated by rejection when a person makes an offer and the person to whom the offer was made responds by proposing changes to the terms of the offer. In this case, the law considers that response of the party not as an acceptance, but rather a counter-offer. An attempt to accept an offer on new terms is a rejection of the offer accompanied by a counter-offer. An offeree who makes such an attempt cannot later accept the original offer. Termination by lapse of time. An offer which is expressly stated to last for a fixed time cannot be accepted after that time. Termination by occurrence of a condition. An offer which expressly provides that it is determined on the occurrence of some condition cannot be accepted after that condition has occurred. Where a person examines goods and makes an offer to buy them, it will not be or it will be an implied term of the offer that the goods should remain in substantially the same state they were in when the offer was made. Such an offer cannot be accepted after the goods have been seriously damaged. Termination by death of a party. It is possible that the death of either party will terminate the offer, as the parties can no longer reach agreement. This is particularly so in the case of personal contracts. Termination by supervening incapacity. If an offerer becomes a mental patient, he would generally not be bound by an acceptance made after this fact had become known to the offeree. Invitation to treat. This is an expression of willingness to enter negotiations, which it's hoped will lead to the conclusion of a contract at a later date. The courts have ruled many situations as invitation to treat, rather than offers. The following have been deemed invitations to treat by the courts. Display of goods for sale. Generally speaking, a display of price-marked goods in a shop window is not an offer to sell the goods, but is an invitation to the customer to make an offer to buy. Display items are simply placed in a position to attract an offer. They are not by their mere display offers that would only require acceptance for there to be a binding contract. The customer makes an offer to buy when he carries the goods to the cash desk. The shopkeeper may then accept or reject the offer. The rejection can come about if the sales clerk refuses to make the sale for whatever reason. It was the purchaser who made the offer by presenting the goods at the cash desk. In the case of Fisher and Bell, the defendant was prosecuted for the offense of offering a knife for sale contrary to the restrictions of Offensive Weapons Act. He had displayed the knife in the shop window with a price ticket which referred to the item. The allegation was that such action was carried out with the object of attracting the attention of a buyer of such knife and selling it to such buyer. The question was whether the exhibition of the knife in the window with the ticket constituted an offer for sale within the statute. The court held that the display of an article with a price on it in a shop window is only an offer to treat. It is in no sense of the ordinary law an offer for sale, the acceptance of which constituted a contract. If Parliament had intended such a display to be an offer, it would have used such words as offering or exposing for sale. Advertisements. A newspaper advertisement that goods are offered for sale is not an offer, but only an invitation to treat, and this was stated in the case of Partridge and Crittenden, 1968. Auction sales. At an auction sale, the general rule is that the auctioneer offers goods for sale. That is not an offer in law. The offer is made by the bidder and may be accepted by the auctioneer when his acceptance is signified in the traditional manner, for example, the fall of the hammer. Before acceptance of the fall of the hammer, the bidder may withdraw his bid. Tenders. Governments frequently purchase goods and services by tender. The statement that goods are to be sold by tender is not an offer. The person inviting tenders is not bound to sell to the person making the highest bid. The statement inviting tenders for the supply of goods or for the execution of work is not normally an offer. The offer comes from the person making the tender. There is no contract until the person asking for the tenders accepts one of them. Sale of shares. A company which makes an offer to the public asking them to subscribe for shares in it does not in law make an offer to sell the shares. It invites members of the public to apply for them, reserving the right to decide how many, if any, to allot to each applicant. This is the end of the topic. Please check the video description for the cases in relation to this topic.